So the session today, yes, is about getting your employees back to work, and it's focusing on HR's role in relation to certain health and safety matters. And we thought the timing for that would be perfect given recent developments. So the agenda is for us to cover 3 topics. I'm going to start by speaking about some of the consultation obligations that employers have in relation to certain health and safety measures to allow staff to return to work following the COVID crisis. Nicola is then going to look at how to respond if employees either refuse to attend work or if they get there and they want to go home. And we've all had that feeling from time to time, but she's going to look at what is a belief in a serious and imminent danger, which might justify saying no, and whether that covers also travel to work as well as being at work. And then we're going to finish off with looking at some whistleblowing protections in relation to return to work and how to deal with and anticipate any complaints. So, as everyone knows, as of last weekend, the UK government announced that it would be encouraging certain employees in England, at least, to go back to work if they couldn't work from home. The same message wasn't delivered by the Scottish government, but it is clear that in both England and Scotland and elsewhere, over the next few weeks and months, some employers will be getting ready to reintroduce certain employees back to the workforce. And for some employers, they've been operating throughout lockdown in any case. So this week, the UK government published 8 sector-specific guides just a couple of days ago, which is to help employers to comply with their health and safety obligations. And these guides make it clear that they don't replace existing health and safety laws. They work alongside of them, and they're designed to help employers to comply with those obligations. And they also make it clear that they also work alongside existing employment laws, such as discrimination laws, and they say that employers must remember to comply with those too. Although the guides do make a specific reference to the fact that public health is devolved in Scotland and Northern Ireland and Wales, and they make reference to the fact that you should therefore, if you're operating in one of those jurisdictions, be conscious and aware of any additional local laws and local guidance which might be produced by the governments in those places. I do think that some of what's in the guides will be of relevance to employers across the UK, and there'll be many employers operating across different jurisdictions. So it's important to take a look at those, but to be mindful of any local differences in the law. For example, in relation to social distancing, there can be differences between Scotland and England in relation to that. The guides make it clear that employers should be carrying out COVID-19 risk assessments, and critically that they should be consulting with health and safety reps, either appointed by trade unions or by the workforce. And that's specifically dealt with within a couple of pages of each of those guides. So there is an emphasis there on consultation. So we thought today it'd be useful to explore what those consultation rules are. But one of the reasons for carrying out consultation, I guess, isn't just to comply with your legal obligations. It's going to be fundamental in terms of building trust with your workforce and getting people back to work, that there is consultation. So it's going to be important for a whole range of reasons, and also hopefully to avoid the complaints and concerns that Nicola is going to sort of cover later. If you get it right in the first place with consultation, that should avoid problems at a later date. And one of the things that the guides does say is that the people actually doing the job on the ground are often the best people to sort of comment on any health and safety measures or controls that are proposed. And I think that's really critical to remember throughout. So consultation's got a number of functions, and one of them is that valuable input can be sought. So if we can just go back actually to the previous slide. In terms of what the legal position is, starting with the legal framework. So there's obligations in the Health and Safety at Work Act, which make it clear that it's the duty of every employer to consult with representatives about making and maintaining arrangements to ensure health and safety at work of employees, and also secondly to check the effectiveness of any measures. And I think that second point's important. Consultation's not a one-off event. It may be that you do consultation to get people back to work, but revisiting on an ongoing basis whether those measures are being implemented effectively, whether they're being complied with, whether there's improvements to make in light of new information or new government guidance, is going to be an ongoing process. So in addition to that, provision in the Health and Safety at Work Act itself. There's also 2 sets of regulations on health and safety consultation which employers need to know about. The first set from 1977, which are on the slide there, deal with a situation where a trade union is recognised by the employer. And in that case, it's the trade union that picks who is going to be the sort of safety rep for the purposes of consultation. They're not elected by the workforce, it's the trade union that decides. And the second set of regulations, which are from 1996, so far more recent, they are for employers who either have no union in place at all, or they've got a part of their workforce where the trade union's not recognised. And for that part of the workforce, then those regulations set out what the consultation obligations are, and also they say that it should be employee rep should be selected through either an election process, or it is possible for the employer to consult on an individual basis. So we're going to have some employers who will have to consider one set of regulations, some might have to deal with both. And I've also, it's also worth bearing in mind that there are a separate set of regulations dealing with offshore workforces, which I'm not going to get into today. So moving on to the next slide, I thought it'd be helpful to outline what you need to consult about. So there are a number of measures in the regulations that have to be consulted with over. First of all, any proposed measures which may substantially affect the health and safety of employees. So that's going to cover measures relating to COVID, risk assessments to do with that, and measures which the employer is going to put in place to try to control those risks. There's also to be consultation about any health and safety information that the employer is required to provide, and I'll cover what that is in a minute. Planning and organisation of health and safety related training, including, for example, health and safety inductions. So we're seeing some employers start to design and implement inductions for people who are preparing to go back to work, to explain what measures they're putting in place to deal with health and safety risks. So that's something you would consult about. And also the health and safety implications of introducing new technologies, and that might be relevant in relation to COVID if employers are, for example, going to introduce apps or other measures to enforce social distancing, for example, or if they're going to be doing temperature tests for employees returning to work. So there could be a technology element of that which needs to be covered by the consultation process. And the final point in the regulations that needs to be consulted about is if there are any arrangements for getting competent people to help them to comply with health and safety laws. So if there's a need for experts. In terms of information, the employer is obliged to provide sufficient information so that the reps can participate fully and effectively in the consultation process and to carry out their functions. So what that means in practice is providing them with details of any risk assessments, measures that are proposed to control those risks, and also what employees should do if there is exposure to a risk. So there's no sort of rocket science about it. It's about providing the information that they need to do their jobs, and then carrying out a kind of meaningful consultation process. And HR people will be familiar about what that means from other contexts, such as redundancy and TUPE consultation. So that's about providing information, consulting in good time, so there's no minimum time frame for it, but it should be in sufficient time for the consultation process to be meaningful. That might be a challenge in some contexts with COVID where things are being done at a pace, but the consultation period would be whatever's reasonable in the circumstances. And the employer's job is to respond meaningfully to points that are made. So if objections are made, if new information is provided by staff, it's a two-way process and a meaningful dialogue. You don't need to reach agreement at the end about the measures, but by going through that sort of meaningful consultation process, hopefully the outputs of that are better and you've got engagement within the workforce who are hopefully happy with whatever is proposed. The ACAS guide on coronavirus is also worth taking a look at. That also emphasises the importance of consulting with your staff about any return to work and health and safety measures being put in place in preparation for that. So just briefly to sort of compare and contrast those two sets of regulations that I've mentioned. So the one's the 1977 ones dealing with trade union reps. They have broader functions than the elected employee reps in the later regulations. So although they have the same role in relation to consulting about health and safety measures which are proposed, they also have additional functions. So for example, they have a role or the ability to participate if employees make complaints, and they have the ability to make representations to the employer about that. So that's just something to think about if you're designing any sort of complaints process. So how are you going to deal with it if people have got concerns about health and safety matters? So those trade union appointed reps would have a role in relation to that. And they also have certain functions in dealing with the health and safety exec, if that's relevant. Whereas the elected employee reps have more of a narrow function, so just the consultation requirements that I'd outlined earlier. Both types of reps have an entitlement to time off to carry out their duties, to appropriate training, and it may be that if you're asking people to carry out these functions for the first time, that you want to provide them with some training about what their role is and what the statutory kind of duties and obligations are in relation to that. And any of those reps are protected from any sort of detriment for performing their functions, and would have the right to complain to a tribunal if there were any sort of disadvantage that they suffered as a result. So just worth bearing that in mind. And there are also certain health and safety offences if you kind of completely ignore these regulations. And it may be that in the past certain employers have given a light touch in terms of consultation on health and safety matters. But with COVID, I think there's going to be a real emphasis on this. It's front and centre of everybody's minds, and the risks to individuals are potentially significant. So I think there might be a shift in emphasis from what we've historically seen in terms of consultation about health and safety matters. So some practical issues to think about then, if you're setting up a consultation forum for the first time. So how often to meet? I would have thought at the beginning, when things are changing quickly, those sorts of meetings might take place on quite a regular basis, whereas when things settle down, it might be that you need those less frequently. But any sort of changes in relation to information about COVID or government guidance are going to have to be consulted about. So I would have thought the frequency would be quite regular at the beginning. Other things to think about are how you're going to disseminate information easily to staff and how to collect feedback. So if you're going to have representatives carrying out this consultation function, are you going to help them to disseminate information through email or intranet sites, etc., or in other ways? And are you going to do that on top of any kind of function that the employee reps might have in disseminating information themselves? A key point for employers will be who aren't covered by the trade union provisions are to decide in the first place, are you going to consult individually or do you want to have reps in place? And I would have thought for any sizable workforce where you've got several hundred or even thousands of employees, it would make sense to consult with representatives rather than have potentially hundreds of employees sending you their individual feedback and concerns. So having representatives in place is likely to make the process more manageable for that sort of situation. And there aren't, we've been asked, I guess, whether there are specific election requirements set out in the legislation for putting in place reps for those employers who don't have them in place so far. There aren't statutory provisions on that, but there is guidance on the Health and Safety Exec website about making sure those elections are fair and open and transparent. And there's some sensible guidance up there about how to get reps in place and to decide how many you need, for example. So that's worth taking a look at. And then training, are you going to give training to your employee reps? And how are you going to deal with their role if they get complaints passed up to them? What is the process going to be for involving them, whether they're trade union safety reps or employee reps? And yeah, just before I pass on to Nicola to cover the next section, it's worth bearing in mind that the risk assessments which employers are going to have to provide and put in place to deal with COVID have to be published on their website if they've got more than 50 employees. That's one of the recommendations in those COVID secure guides that came out earlier this week. So the focus very much is on transparency, and maybe that is a difference to what we've seen before. I think because of that, we're likely to see more employees being interested in those and possibly feeding back on them. I'll hand over to Nicola now.
Thank you very much, Elaine. So I'm now going to have a look at how employers should respond if employees say that they don't want to go back to work. This is a likely scenario in the current circumstances. So the Employment Rights Act 1996 gives employees protection from dismissal or detrimental treatment if they leave work, refuse to attend work, or if they take appropriate steps to protect themselves in circumstances of danger which the employee reasonably believes is serious and imminent and it cannot reasonably be controlled. So in this scenario, if an employee was dismissed for the reason that we've set out, this could lead to a potential claim for automatic unfair dismissal. This is a day one right for employees, so no 2-year service isn't required. Equally, if an employee was subjected to a detriment for this reason, they could bring a claim on that basis. Again, that's a day one right. A detriment is a very wide-ranging term, but it could cover any kind of disadvantage. So in this context, it might include being subject to disciplinary action for not attending work or possibly not being paid. We've also put on the slide here, does this protection, does it extend to travelling to work as well as risks at work? Well, yes, it potentially could. If an employee reasonably believes that a commute would place them in serious and imminent danger, then they may be able to refuse to travel to and from work. This would obviously have to be considered on a case-by-case basis. There's no case law on this within a COVID context, but it has been considered previously by the Employment Appeal Tribunal. We saw that in the case of Edwards versus Secretary of State for Justice a few years ago. And in that case, there were 13 prison officers at Durham Prison. There had been particularly bad snowfall, and these prison officers refused to travel in a 4x4 on a closed, hilly, icy road to get to their place of work, which was the prison. As a result of that, their pay was docked, and the Employment Appeal Tribunal accepted that travel to work was within the scope of this serious and imminent danger protection that we've talked about. The considerations which the Employment Appeal Tribunal looked at here were there circumstances of danger? Did the claimants consider them to be serious and imminent? And also in this case, the EAT said that it didn't matter if some other employees in the prison made the journey without difficulty or danger. So it is arguable that these serious and imminent danger protections could extend to travelling to or from work within a COVID context if an individual said that they had a reasonable belief that public transport, for example, would put them in serious and imminent danger. And that might even apply if other employees were making the journey in public transport without difficulty. Given that we've been in lockdown for some time and everything that we're hearing on the news about this virus, you can understand why people will feel particularly concerned about returning to work. And it's easy to see how an employee might reasonably believe that there was a serious and imminent threat from COVID-19 in many workplace situations. What we've done is we've outlined a scenario here to see if we can consider these protections in a little more detail. So I'll just briefly run through this. So Adam is concerned about returning to work to a factory in town. He has diabetes, so has been worried about contracting COVID-19 as he thinks he is in a higher risk category. He cannot drive to work and he lives 10 miles away, so he needs to get the bus. Although his employers assured him that certain social distancing measures have been put in place, he is worried that when he gets to work, there are some occasions when he just won't be able to maintain a 2-meter distance from his colleagues. He also thinks that he should be provided with a visor if he needs to be in contact with the public. He has said to his supervisor that he doesn't want to travel to work on public transport, so he says he isn't going back until something changes. He has only worked for the company for 6 months. So usually where an employee refuses to go to work, it would be reasonable in that scenario to engage in a disciplinary process. But given the special protections that we've mentioned here, marching down a disciplinary route without pausing and considering matters would not be a good idea. That doesn't mean that you can't tackle or deal with it, but there are tricky issues here, and the employer will need to find practical ways of trying to resolve it. So we've set out some of the considerations which are likely to be relevant here. We know that Adam has diabetes. Medical conditions certainly should be considered. His diabetes is likely to be relevant, as it will mean that he is in a higher risk category for the virus. We also know that his employer has complied with government advice and they've carried out risk assessments. Obviously, that's very positive that they've done that and they've put in place adequate safeguards, they've adhered to government guidance and carried out risk assessments to minimise transmission of the virus. That said, his employer may be following government guidance to an absolute T, but Adam may still have a reasonable belief that working isn't safe. The focus here is the employee's reasonable belief rather than the employer's opinion. Adam might still have a reasonable belief here about the danger he will face for a number of factors. That might be his own medical condition, because he's having to use public transport, or possibly there's some element to his role which will involve dealing with the public face-to-face. We've also said, can he make his own decisions about PPE? If these points were to arise, you'd probably want to go back to the risk assessments. It's likely that equipment would have been considered as part of previous risk assessments. Refer back to these and see if you can alleviate its concerns by considering those again. If specific suggestions have been made by the employee which hadn't previously been considered, try and refer that back to the Health and Safety Committee. If you have one, getting their input will obviously be helpful. The next thing we've said is, are line managers trained in how to pick up on such issues and to know when to involve HR? This is really important. You need to make sure that HR are involved at an early stage so that line managers aren't taking these decisions into their own hands, and to ensure that the correct process is followed. So what should that process look like? Obviously, concerns could be addressed through the employer's grievance procedure, but there may be a speedier way to deal with it, possibly on an informal basis, bearing in mind the serious and imminent danger protections which do exist. Obviously, dealing with it quickly and promptly is important to try and limit other employees jumping on the bandwagon with similar concerns. It could also be important, as you might want to consider temporarily paying these employees whilst you're dealing with the concerns, so the quicker you can reach resolution on these matters, the better. The key point here is that the employer should be asking Adam to explain exactly what his concerns are about returning to work, and these should be specific enough so that the employer can pinpoint the particular processes or elements which are causing him concern. That detail will then in turn allow the employer to break down the concerns and advise what could be done to help with each one. So, where does the employer land with this? There's obviously various considerations in play here. They'll need to fully understand, consider and respond to the concerns with input from the Health and Safety Committee, which will be useful to try and practically resolve the matter. It's really important as well that a blanket approach isn't taken. So you can't just say, oh, well, other employees are okay with the working environment and returning to work, so you need to get on with it. There's an element here that it comes down to what the individual's concerns are, what their reasonable belief is, what is their reasonable belief of danger in the situation. Remember, taking a hard line carries risk. So the employer decided to insist that he came back to work, and it said, if you don't, we're going to commence a disciplinary process. That obviously carries risk of an automatically unfair dismissal claim. Other factors, pay, for example, you need to think about that. If you don't pay, there's a risk of a detriment claim. If you do, would this set a precedent for other cases? So various factors to be considered, and I'm now going to pass back on to Elaine, and she's going to talk about whistleblowing.
Thanks, Nicola. Yeah, we're going to finish off by touching on a sort of related type of protection that employees have. And in my next slide, I'm just going to outline the key elements which you'll probably be familiar with, which comprise a protected disclosure, We think there's going to be a significant uptick in these types of claims, and it's kind of obvious in the context of COVID why lots of what employees might be complaining about when they come back to work could comprise protected disclosures. So for there to be a whistleblowing complaint or a protected disclosure, someone needs to disclose information. That can be verbal or in writing, and I guess when it's verbal, it's more difficult sometimes to pinpoint what somebody said after the event. Whistleblowing protections obviously cover people from day one of the employment. Again, you don't need 2 years service to make those types of complaint. And it's also important to bear in mind, they don't just cover employees, they cover an extremely broad definition of worker. So anyone in your premises who's working is pretty much likely to be covered by these protections. And it's for individuals who believe there's some sort of wrongdoing. And the most relevant types of protections in the context of COVID would be an employee alleging some sort of breach of a legal obligation. So if they have a reasonable belief that their employer hasn't complied with certain health and safety measures, that would be covered. And there are specific provisions in the legislation to deal with health and safety in particular. So it's very easy to see how an individual could jump through the hoops that they need to be able to demonstrate that they've made a protected disclosure. So how are employers going to deal with that then? A critical point is to make sure that your line managers are trained enough to spot what could be a protected disclosure, and again that they involve HR at an early stage so that you can decide what the best process is to be able to deal with it. You don't want line managers just sort of discounting people's concerns and not kind of being alert to the fact that they could have this sort of protection from having raised these points. So training your line managers to spot them, being aware of how they respond to people. When you get claims, a lot of, I guess, the ability to defend those claims or otherwise can depend on what was said in writing and email correspondence, etc. So reminding your managers that everything is disclosable in the end, and to be mindful when they're sort of dealing with concerns about what they're saying and how they're saying it. Dealing with the issues promptly, again, similar to what Nicola said, is going to be critical, and maybe that you don't want to go straight down through a sort of formal whistleblowing process. It might be that you can have a quick discussion with somebody and deal with any concerns that they're raising without having to do that. But for the more serious concerns or issues that don't go away, having a whistleblowing policy there is going to be critical. And then in terms of risk for employers, there is the risk of employment claims, which I guess for whistleblowing is uncapped compensation and injury to feelings awards on top of financial compensation. But actually, some of the biggest risks here can be the risk of adverse PR for employers. We've been seeing the trade unions encouraging employees actually to complete forms to make disclosures direct to the HSE. So there is going to be a risk of HSE investigations as well as the actual whistleblowing risk itself. So I think there's lots of lessons to be learned, even from the experience so far with COVID, where we've seen the NHS have lots of issues with employees at work being unhappy with PPE being provided and other health and safety measures, and the adverse PR and other risks that have come out of that. So that's about all we've got time for. We're going to deal with a couple of questions briefly. Nicola, have you got any questions come in on the Q&A box?
Yeah, there's a few here, so I'll take this one. So in the example you provided, the employee had a disability. What do we do about that if there is a greater risk for the individual attending work? Is there an obligation to make reasonable adjustments as well as to consider the health and safety issues? In response, yes, you're right. Adam has diabetes, so he may well be disabled under the Equality Act, so this makes the situation more complicated. And yes, there would be an obligation to make any reasonable adjustments for him, in addition to considering the health and safety obligations, and also bearing in mind the serious imminent danger protections available to him. And all of this would really just have to be weighed into the balance when considering a return to work for him. Elaine, there's another one here. I don't know if you want to take this one. If we have to publish our risk assessments, which the government has asked us to do we know what will happen with them and what is the purpose of that? We haven't done that before.
Yeah, I think this is quite new for lots of employers. I don't think many employers would publish their risk assessments on their websites as a kind of matter of course. And we don't really know what the exact purpose of that is and what's going to be done if employers don't comply with that. It might be that the HSE would be interested to know if employers have been doing that, or it might be that they just recommend that as a good practice suggestion so that there is transparency about what measures are going to be put in place to protect employees' health and safety. But yeah, that's a kind of watch this space one. I see there is a question here. How do you manage individual employee opinion and the actions you put in place for them versus not providing these for all other employees? I guess that kind of links back to the scenario that Nicola outlined earlier, where maybe one employee saying, I want to bring my own PPE to work, or I don't accept your findings in your risk assessment, I want to have something different for me. I can see there could be a problem with that if you end up with everybody doing their own thing instead of the employer assessing the risk and deciding what the measures should be. And there would be a consistency issue there if you were to allow one person to do one thing and have different health and safety provisions in place for other people. So that would need to be managed. But I guess, yeah, talking to the individual and trying to explain why certain equipment may or may not be needed according to the experts or whatever might be a way to try to manage that. Nicola, do you have any other questions?
I'm conscious of time, but we can maybe just squeeze this one in very briefly. On health and safety consultation, if we have an employee forum which isn't set up to deal with health and safety issues, can we use that to consult with staff?
So, as I mentioned earlier, there's no specific legislative provision saying how you should elect employee representatives if the trade union provisions don't apply to you. But you would want to make sure that whatever organisation or employee forum that you've got in place is suitable to be consulting about health and safety matters. So if when the employees selected them in the first place, they didn't ever, for example, if they thought it was going to be a social committee or something, it may be not appropriate to go and consult with that body. So you want to look at how it was described in the first place and whether it is sensible to use that body, or whether you go ahead and have an open and transparent election process as the HSE recommends, and have a body put in place that's suitable to consult with about health and safety matters. And given the seriousness of the health and safety issues here, it may be that you want to put in place a specific body to do that, where everybody knows that that's what they're going to be doing and where they've got appropriate training and things in place about what their duties are. Thanks everybody for joining, and we will circulate the slides and recording later, and we'll come back to you on your questions if we've not had a chance to answer them.
Thank you.